welcome to our panel discussion on the use of insolvency tools and techniques in international judgment enforcement. Thank you for making it here. I will firstly introduce the panel. To my right is Daria Plakhova-Freshville, a senior associate at Alaco. Daria has joined Alaco in 2017. Particular regions of expertise are Russia and the other countries of the former Soviet Union. She works in a wide variety of cases, including litigation support and other legal disputes, fraud investigations, international asset tracing, integrity, and competitive due diligence. To Daria's right, just checking I have the right person, is Colin. Colin is the director of Grant Thornton, and he focuses on asset recovery and enforcement and the use of insolvency tools to recover assets. To Colin's right is Louise Trayhurn, an executive director and co-founder of the London office of Legis Finance. She's a qualified solicitor with over 13 years of litigation and litigation finance experience. As well as broad experience working on a variety of disputes in private practice, she has helped to originate, structure, and execute numerous finance matters, and now assists in combining risk mitigation tools with litigation investment to provide bespoke solutions to law firms and their clients. Finally, at the end, last but not least, John O'Driscoll is a partner at Walkers Global and heads up the insolvency and dispute resolution team in London. He practices both BVI and Cayman law. My name is Mark Griffiths. I'm a partner at Kobre Kim with a background in international insolvency and commercial litigation. I now focus on global insolvency, disputes, fraud, and asset recovery. So turning to today's panel, I'm going to give a brief introduction before we move on to the case study and some of the more substantive parts of it. As I mentioned, the purpose of today is to look at the use of insolvency tools and techniques in judgment enforcement. I suppose at the start, it's important to note judgment enforcement uses a great range of ways of exerting pressure on the judgment debtor in order to achieve assessment or to monetize the judgment. The aim of today is merely, or is to explore those ways that insolvency can be used and can assist in that process. I think as a background to this, it's worth noting that as market conditions have changed, we all look for ways to obtain higher value work. As we move into any matter with an asset recovery risk, then a client can more easily see value in paying higher fees for that. And so I think there's been some movement in the insolvency profession where insolvency practitioners who typically apply their skills, their expertise in, fraud, offshore funds, all of the areas that we typically see them working in, are now looking potentially at, and more focusing on other areas such as, pure asset recovery and naturally as a consequence of that, judgment enforcement. So looking at today's discussion, I think, if you look at the enforcement toolkit, the aim is to increase pressure and to optimize monetization. And I think it's very easy for professionals to sometimes forget that all their clients are really interested in is actually the economic outcome. And sorry, I thought there was a question, which had been rather early. But they're focused on the economic outcome. Those clients that aren't initially focused on the economic outcome, I think soon do after they receive months and perhaps years of bills from their professional advisors. So, when we're looking at this, I think that's the underlying point, is how to create that, that pressure that leads to a judgment debtor actually paying out on the judgment. In order to assist with today's discussion, we've developed a simple case study, and we will be touching on a number of jurisdictions and areas outside of insolvency. Some of those jurisdictions are not represented on the panel here today. We've included them because I think it makes the case study more interesting and more usable. There will no doubt be members of the audience who have specialist knowledge, and we welcome their thoughts at the end. Just to introduce the types of, or just to introduce the subject, I suppose, in terms of some of the insolvency-related considerations that we will be looking at is firstly to understand that at the very outset, and this is obviously stating the most simple point, that an arbitration award or a judgment will constitute a debt. And that's something that can immediately be acted upon by the insolvency professionals, as opposed to the process of recognition and then enforcement that can be quite time-consuming if you're going down a more traditional recognition enforcement route. There are also measures that can immediately be taken to safeguard and protect assets and take control of structures, either directly in the area of insolvency, such as liquidation or provisional liquidation, or those areas that sort of surround formal insolvency processes, like receivership. It also allows office holders to investigate, and there's significant investigatory powers that office holders have, and to investigate those transactions that have extracted value from those structures that are controlled by or owned by the target, the judgment debtor. So there's a number of advantages. Also the fact that you can enter into jurisdictions through the recognition regimes, and you can effectively target those jurisdictions where the judgment debtor is active or has value. Moving to the case study, John will give more of an introduction, but it is high level. There is more than this that will come onto the screen, but it is high level anyway. It's meant to prompt discussion and be used for the panel to provide them with a background to discuss some of the points. The panel will, and I'll move on in a moment, but the panel are going to talk through some of the insolvency tools that can be used in terms of working the way through this structure. With that, first key jurisdiction, I think, we're looking at this, or one of them, is BVI, and I'll pass over to John.
Great. Thanks very much, Mark. So what we have here is a fairly straightforward corporate structure. We have a Cayman Island entity called Credit Limited, which is owed $300 million by Defaulter Limited, which is a BVI company. A company called Goldmine, which is a BVI holding company, sits below those two. The breakdown of shareholding is 80-20%. And then we've got a English company, a Cayman company, and a Cyprus company. So just to introduce, at Defaulter, there is a bank account which holds $5 million, and that's an English bank account. Of concern, it appears that $50 million has been misappropriated out of Goldmine Limited through an English bank account, and it appears to have made its way up to Mr. Vortex, which is our bad guy. And then through our corporate investigation team, we've unearthed some assets. So we have a high-value property, which is owned by the English company. We have a security over a super yacht owned by Liner Limited. And we have a hotel and resorts group which sits under Resorts Limited. So the key thing really here for the ultimate beneficial owner, which is Miss Wynne on the top right-hand corner there, as you can see, she's already counting her money, which is perhaps a little bit early. What we really need to do here is preserve assets, take control, and then realize value from those assets. The first tool, the first insolvency tool that we'll look at today is provisional liquidation. It makes sense on the basis of urgency and as a protective measure to put Default Limited into a provisional liquidation process. Usually you would appoint a provisional liquidator where there has been some dissipation or assets are in jeopardy. And as we can see lower down in the group, it appears that misappropriation has taken place. This would hopefully provide evidence and allow us then to appoint a provisional liquidator over Defaulter Limited. So you need a good arguable case to appoint a PL over a company in BVI. The court will look at the benefits to the creditors as a whole, if there has been a dissipation of assets or not, and if there's real urgency. So taking it that we have a PL in place, the other point to mention about a provisional liquidation application, because we have an arbitration award of 300 million, there is no need in the BVI to have that recognised firstly before you appoint the PL. You can go straight to enforcement. So that means you can deploy the provisional liquidation process as a very urgent type of application. The other point to mention is that the PL, once he's in place, he is there to maximise recoveries for the benefit of all creditors and not just Credit Limited and ultimately Miss Win. Colin, I think you were going to mention about the bank account and some practical steps you would take in relation to that.
Yes, as the liquidator in BVI, I'd be very interested to get my hands on the £5 million of cash in that bank account in England. From a practical and commercial perspective, it de-risks the engagement for Miss Win. It de-risks the assignment for the professional advisors and the liquidator. And essentially it provides a small fighting fund to finance the seed capital and finance the take control strategy that Mark and John have alluded to. It also would enable me as liquidator to build out the factual matrix of the situation and hopefully obtain a deeper pool of finance to fund the wider multifaceted enforcement strategy that we'll be talking about here today. In terms of actually freezing or blocking that account in the UK, John mentioned or alluded to earlier a couple of interim measures that might be available in the UK. We could potentially look to obtain a freezer or even appoint a receiver over that cash. However, one practical, relatively quick, cheap solution would be for the liquidator to put the bank on notice in the UK that they've been appointed and to freeze and block funds from being distributed. Essentially putting a bank on notice that if they do allow the funds to be dissipated, the liquidator may well be knocking at their door in relation to a facilitation for enabling that money to be dissipated. Ultimately, the BVI liquidator, me in that instance, would look to have their appointment recognised in due course in the UK. But I think Mark's going to touch on that in a few slides' time. But I think for now, back to John to talk about taking control down the group structure at Goldmine Limited.
Yeah, so we have a PL in place over Defaulter Limited, and next we'll be looking to take control over Goldmine. What we would need to determine is if the directors of Goldmine are friendly or not. If they're not, we will then look to change the board and take control that way. Another possible option, and this would depend on the order that the BVI court gives in relation to Defaulter Limited, is to look to appoint a liquidator over Goldmine. And this could be done out of court through a process known as a qualifying members' resolution, where you require 75% in order to appoint a liquidator. It is quite a useful process because it can be done very quickly. So we could have the PL in place over Defaulter, and then immediately after we could seek to have a liquidator over Goldmine, and that could happen pretty much same day. Daria, how would we investigate and unearth assets at this point?
Well, of course, the beauty of this structure is in the fact that most of it at the head level sits in offshore jurisdictions where you cannot see the ownership, you cannot see the directors, and of course we would not all be here had those jurisdictions not provided those services. So our job as an investigator to come in and start building below the head structures, starting to build seizable asset base that is useful. We will always do it in conjunction with you because there will be certain jurisdictions that you will favor in terms of enforceability, in terms of unified efforts, in terms of timing, because we know that is absolutely critical. We will also be looking at the assets which are as current as possible. We will concentrate on fixed assets rather than liquid assets if possible. And I know we're talking about liquid assets here as well, but they can move quite quickly and can create a problem. So how do we do all that? Well, the beautiful power of public record, of course, is incredibly helpful. And in fact, the more there is available and the more the internet develops, the more pressure there is on us to come up with something that is usable as evidence in court, and that is not available to everyone who is a savvy internet user or has access to all the databases. And the way we do that is by learning absolutely all tricks of the trade in any given jurisdiction. And the amount of times it led us to, like, say, head BVI companies is absolutely amazing because, say, for example, you can never see the ultimate ownership in the offshore zones. In a lot of documents, even prospectuses, you'll still not see it in most European jurisdictions, but some will actually sometimes disclose, like, say, we once cracked a case by going to a very local shareholders ledger in a certain canton in Italy, which actually listed it simply because that is a local requirement. And knowing little bits like that certainly helps you because then you come up with the evidence that you would not otherwise have. But you basically cannot afford to be lazy as an investigator. The point is, today you have to work harder than ever before to give that extra value, especially if you're looking for something very current. So you just have to almost stay one step ahead of the game. Intelligence gathering can be helpful because it may lead to hidden assets, which you can then trace through public domain, and that happens a lot. But you also have to be quite careful because you can't always use it as evidence. What you can use it is as pressure tools in negotiation with your opponent, and that can indeed be very useful. And vulnerabilities. People structure their assets sometimes, like, very cleverly, and sometimes there will be something somewhere that will give you that one extra clue. So, and we will be looking for those weaknesses in corporate structures, and quite often people ask us to start with that, like, where can we pierce that corporate veil? Where can we find how they are structuring hidden assets? And of course, doing all of this work enables you to understand your opponent's modus operandi in general. So down the line, you will know where you need to look next, what might they do next, and that is usually quite helpful. Like, say, in this case, we see that it leads to resorts limited in Cyprus, and in fact, that's where we see quite a lot of assets being found. One might consider involving MOCAS, the equivalent of the Finance Intelligence Unit, which will have further access to all of the documentation. But Colin, you were going to tell us a little bit more, like, once we did find those assets in Cyprus, what happens next?
Sure, and thank you for the good work. Appreciate that. As you can see, Resorts Limited holds Hotel Empire and Retail Group. The group appears to be trading profitably, and we need to preserve the enterprise value in the Hotel Empire and the Retail Group to maximize realizations and to preserve that enterprise value. Now, to preserve that value and take control of Resorts Limited in Cyprus, we think there are three main routes and options that are available to the BVI liquidator. The first of those is a members voluntary liquidation, which is an MVL and a solvent winding up. The second option is a creditors voluntary liquidation, which is an insolvent winding up, but an out-of-court process. And the third option is a non-insolvency route, and that's to change the directors and take control of the board of Resorts Limited. There are three sort of fundamental questions that we need to ask. Are the directors of Resort Limited hostile or are they friendly? Is Resorts Limited solvent or insolvent? and who are the creditors of Goldmine Limited. So firstly, let's assume that the directors are friendly. That may seem a bit odd, but from my practical experience, directors of Cypriot companies are often nominee companies, normally lawyers, based in Cyprus. You often find that they have been or have outstanding fees that haven't been paid by the ultimate beneficiary owner, in this case, Mr. Vortex. So quite often the liquidator, or the ultimate beneficiary, in this case being Goldmine Limited, would have to make a ransom payment to make sure the nominees' fees have been brought up to date. But once they're paid off, you normally find they fall into line and could be quite cooperative. So the first option that we're looking at was the solvent winding up, the members' voluntary liquidation. This will require a statutory declaration of solvency to be sworn by the directors in Cyprus, effectively stating that Resorts Limited can discharge all of its liabilities. Once the liquidator is in place, they will be able to pass a resolution to make a dividend in specie and effectively transfer the shares and assets up to the BVI liquidator, or alternatively, the MVL liquidator will be able to trade and realise the assets, in this case the hotel and retail group, and distribute the cash up the corporate structure to the liquidators in the BVI. And it's important to remember here that all the creditors and preferential creditors would need to be paid off in full before there is a distribution up to the shareholders. One of the key creditors that will be in Cyprus will be the Cypriot Tax Office. It can take some time for the Cypriot Tax Office to let you know what any potential liability is there. We're certainly talking months, not weeks, in that respect. Under some circumstances, the liquidator may be able to get an indemnity to enable an early distribution, but it's always quite difficult to find the individual or corporate that will give that liquidator the indemnity they require. The second option was the CVL option, so creditors voluntary liquidation. This would entail the shareholders and directors of Goldmine Limited to pass a relevant resolution to place Resort Limited into liquidation. Under Cypriot law, that would be a special resolution, which will require 75% of the voting rights. So in our scenario here, we're 100%, so we can pass that resolution. Importantly, this is an out-of-court process, so it can be done relatively quickly. But it's important to remember that it's a creditor's voluntary liquidation, and therefore the creditors will control which liquidator is appointed to Resorts Limited. Happily, in our case, there is an intercompany debt due to Goldmine Limited of 100 million, which gives it the majority debt position, and therefore Goldmine Limited can appoint myself and colleagues liquidated in Cyprus. Again, all preferential and normal creditors would need to be paid off in full before any distribution up to the shareholder. And then the third option that we were looking at was the ability to change the directors and take control of the board. So under company law in Cyprus, it would be possible for Goldmine Limited to remove the directors that are incumbent at the moment with a simple majority resolution and replace them with directors of its own choice. It ordinarily takes 28 days notice in Cyprus to remove the directors. However, after 28 days has expired, you will have effective control and running of the board in Cyprus. But let's take a step back. Let's assume for a moment that directors of Resorts Limited are hostile and they are loyal lieutenants of Mr. Vortex. 28 days is an awfully long time for them to cause havoc and diminish value in Resort Limited. So one practical step that we've taken in the past is to have Goldmine Limited appoint a director or more directors to the board. That takes a simple resolution, which we will be able to pass. Furthermore, we would amend the Articles of Association in Cyprus that would stipulate that all decisions would require a unanimous vote therefore fettering any incumbent directors from making decisions that might dissipate the assets. As John alluded to just earlier, there is a web of companies that hold these assets. To the extent that there are subsidiaries in Cyprus, the options we've just been through would be applicable to those. But also, from my experience, tend to see structures involving BVI, Cayman, English, Singapore, and Hong Kong entities underneath these structures, and similar techniques and tools to replace incumbent directors and also put liquidators in place is normally available in those jurisdictions. But for now, I think it's back to John to talk about the powers that are available to a liquidator in BVI in Goldmine Limited.
Yeah, thanks, Colin. And it's also worth mentioning we put a PL, a provisional liquidator, in place over defaulter. As soon as the winding up hearing is held, which could be a matter of 8 weeks later, we'll have a liquidator at that level as well. So we have also a liquidator at Goldmine level, and it's worth, I think, just setting out at a high level some of the useful tools and powers that come with being appointed as a liquidator. Once the liquidator's in office, he's got a full suite of powers to obtain books and records, investigate what's gone on, see if anything has been done incorrectly. He can also interview witnesses and force people to cooperate and cough up information. And here with Goldmine, there's the worrying situation of the 50 million that has been siphoned out, and that is something that Colin, as liquidator there, would really need to get to the bottom of. There are the whole range of clawback actions that could be taken, such as preference claims, undervalued transactions, that Colin could deploy if he needed to. When a company is put into liquidation, there is a moratorium on enforcement, so no claims can be brought against that company in liquidation, and no litigation proceedings can be brought against a company in liquidation. Although I must mention, in BVI, if you're a secured creditor, you can always enforce your security. So that's not something that the moratorium would apply to. When you have a court-appointed officer that acts as liquidator, that individual can then look to get recognised in jurisdictions where there may be assets based. And this brings me back to Mark and the options we might have in the UK following recognition.
Sure. So many here will be familiar with the concept of recognition and assistance, particularly any people in the audience with an insolvency background. Just by way of a basic overview for those who don't, the laws of recognition and assistance will assist the liquidator of Goldmine Limited, in this case Colin and his team, and also any other entities that he's been appointed over, such as the entities higher up the structure, Defaulter Limited. And the application will be to the English courts requiring assistance, recognition and assistance from the English courts with regard to the insolvency proceeding. And that can come in different forms depending on the particular system that is used, but could, for instance, look at the investigation of the misappropriated monies from Goldmine Limited. The UK has one of the most extensive recognition and assistance collective regimes, and these will assist Colin in pursuing the assets further down the chain. Many cases that we will deal with have been decided under either Section 46 of the Insolvency Act or the CrossBorder Insolvency Regulations 2006. Many of you will also be very familiar with the common law form of recognition and assistance, which not so recently now was explained and developed in the decision of Singularis. There is, just by way of completeness, there is of course a European framework dealing with recognition and assistance. But given I'm sure everyone's fairly fed up of hearing about Europe, I won't say anything more about that. So looking at Colin, the liquidator of Goldmine Limited, he will be seeking recognition and assistance of the English court to assist him in our case study with gathering information and investigating the 50 million cash misappropriated through a London domiciled bank account. To the extent any of the £5 million in cash has been dissipated, then a similar analysis would apply. There would be, or are, various sources of cross-border insolvency law that allow the English courts to recognise Colin as BVI liquidator in these circumstances. They would include those that I've mentioned, the cross-border insolvency regulations 2006, which embody the anti-trial model law on cross-border insolvency, Section 46, and the common law. At this stage, Colin will want to consider which of these regimes is most suitable in the circumstances. I'm sure many of you here will have their views. I'm not going to go into a comparative analysis, but for those who are not overly familiar with the regimes, I'll give you just a couple of key points. The cross-border insolvency regulations, so that's the regulations that embody the model law, allow the English court to grant any additional relief that may be available to a British insolvency office holder under the laws of Great Britain. Section 426 is slightly different to that, in that the office holder has a choice whether to apply to the UK court to sanction relief in the form of the insolvency, including investigatory powers of the UK, or alternatively those of the requesting country in relation to comparable matters falling within its jurisdiction. So there's a choice essentially between two different regimes. The common law power of assistance, I think, is more limited now, of course, and doesn't enable office holders to do something which they could not do under the law by which they were appointed, so the requesting country. I suppose it's finally worth mentioning, again for completeness, that there are of course agreements or protocols between office holders that allow an informal means by which they can effectively recognise and coordinate with their respective insolvencies. An insolvency practitioner will also, or Colin will also, always want to consider the benefits of any automatic recognition and assistance offered by certain jurisdictions, and that's obviously where there's a choice in terms of which jurisdiction to commence the winding up proceedings. So if, for instance, in this example, there was a choice with respect to Goldmine Limited of whether to wind the company up in either the BVI or the UK, and that, and it isn't part of the case study, but just hypothetically assuming for the purpose of this point, that the liquidator, Colin, wanted to exercise powers in the EU, then it may be preferable, depending on the particular circumstances, to wind up Goldmine Limited in the UK. The UK would allow this. You're allowed to wind up foreign companies in the UK. There's the sufficient connection test that we're no doubt all aware of, and there's a number of other requirements as well. Whilst we are seeking recognition in the UK, we will also be seeking to take control of Mansion Limited, the UK entity, and I think Colin's going to take us through this.
Yes, again, there's a valuable property in the UK which obviously would like to recover on behalf of the creditors, and particularly Miss Wynne. There would be, again, a number of options available to me in Goldmine Limited to take control of Mansion Limited. Again, potentially looking at a members' voluntary liquidation, creditors' voluntary liquidation, and changing the directors and taking control of Mansion Limited. During the course of our investigation into this particular affair, we discover that the mansion was transferred to Mrs. Vortex following the granting of the arbitration award. Given that set of facts, we feel that it would be sensible to place or seek to place Mansion Limited into a creditor's voluntary liquidation by way of the Goldmine passing the relevant resolutions and directors passing the subsequent resolutions. Of course, there'd be a need to be a full legal undertaking into those options that are available. But let's assume that we pass all those and we manage to place Mansion Limited into a CVL. Once appointed, I'd have unfettered access to the records, legal records, accounting records, tax records in relation to Mansion Limited. And following my forensic investigation, luck would have it that I find out that Mrs. Vortex is resident in London and discover that she paid zero consideration for the mansion that was transferred to her. Under the UK Insolvency Act, I would have the powers to bring an application in court in relation to a transaction under value. So therefore, Goldmine received zero consideration for the mansion. The transaction was entered into 2 years before the onset of insolvency, and at the time of the transaction, or following the transaction, Mansion Limited was unable to pay its debts. So therefore, I would be able to unwind that transaction, claw back the property or consideration equivalent to the value of that property for the benefit of the creditors. In this case, again, Goldmine Limited is the majority creditor here and therefore would seek to benefit from the majority of the realizations of the mansion. During, again, the course of the investigation, we have been ascertaining information in relation to the $50 million that was transferred out of Goldmine Limited, and I think Mark's going to talk through the various legal options that are available to me as a liquidator of Goldmine to claw back the $50 million that was misappropriated by Mr. Vortex.
So I'm going to briefly cover those powers available under the Insolvency Act, the Insolvency Act 1986, which Colin and his team as liquidators would be able to exercise following recognition in the UK, and would be able to use to investigate the misappropriation of the $50 million from Goldmine Limited. These powers are actually quite substantial. They have been described as extraordinary and inquisitorial in nature. They focus, and for those who are familiar with the respective provisions, I'm referring to Section 236. They focus on three categories of person mentioned, or three categories of person are mentioned in Section 236. One of which is a sort of catch-all category and includes any person who the court thinks capable of giving information concerning the promotion, formation, business dealings, affairs, or property of the company. So there's a very wide net to cast in terms of who to actually apply these powers to. There's various relief available. Of course, I think in this example, most of you will not anticipate or expect that Mr. Vortex will submit. If he doesn't, then this creates another avenue of pressure. A warrant can be issued for his arrest if he does not appear, and various sanctions can follow. And part of this multifaceted approach, part of doing a lot of things in a lot of different jurisdictions, is to create more and more pressure globally on a particular target. And if they're in contravention of Section 236, that's going to add to that pressure. There's a number of other powers under Section 236, such as having to give an account of your dealings with the company, and producing any books, papers, records, etc. in your possession, but it's quite a powerful tool. It does, from certainly my experience, or can take time though, and that's one of the issues with going down the formal route. The basis of these powers are relevant to the principles governing them. They derive essentially from the liquidator's statutory duties and functions, which relate to those basic points: collecting in the company's assets, realising the company's assets, investigating potential legal claims, and probing the reasons behind the company's failure or behind the types of value loss that we've been describing. In terms of awarding this type of relief, the court has very wide discretion, unfettered discretion, in fact. It will, however, carry out a careful balancing exercise and firstly ask itself whether the office holder reasonably requires the information to carry out his task. I think here we could say that he would do. Obviously, that's a generalisation. And secondly, the court will avoid making an order which is unreasonable, unnecessary, or oppressive. And it's, obviously considered less oppressive to ask somebody to produce documents than actually appear on oath. Other powers include those under sections 234 and 235. Section 234 is relates to getting in a company's property. 235, duty to cooperate with office holders. So, given a number of those issues, particularly the time frame in terms of investigating formally, we would obviously be looking at these transactions with Erica and with her team to investigate from the get-go and to find information out.
Well, as Mark has just mentioned, usually the situations are incredibly fast-moving, and one of the tricks to stay ahead of the game is to keep an eye on how the whole corporate structure is changing, which companies had been struck off, which would be in the middle of all of these companies, which new entities had been established, and that can happen very, very quickly. And quite often we are asked to almost monitor the situation, well, if not daily, certainly weekly basis. Have we had introduction of new directors, new nominees, shareholders? How did the flow of dividends change? All of those things can be very helpful in understanding how your opponent is thinking and kind of keeping an eye on the situation. We had a case where a Cypriot fiduciary wasn't getting paid, so we were able to approach them in confidence, and they were so angry they told us that their former client had just applied for citizenship in Cyprus, which immediately made us realize somewhere there'll be at least 2 million for us to find in Cyprus. And then once you have that information, actually that can be very helpful. So, but perhaps one of the more important aspects in looking for the money is not to tip off the other side. And that happens quite often as well and creates all sorts of problems. So, because of course the overall idea is to come up with a strategy altogether that is, again, one step ahead of the person who is hiding the money. So this is on a personal level. Quite often we ask to look for money on behalf of sovereign or belonging to a state. So that's a slightly different game because even though, once again, it is structured quite wisely, quite often if you go to the original underlying materials, like say in former republics of the USSR, quite often you'll have government contracts, which somewhere in the documentation will tell you on whose behalf that contract with that BVI entity is signed. So, and there you have your legal tool with which you can go in the jurisdiction that you can act in and either use it as a negotiation tool or indeed to proceed. So, but all in all, I think coordination during this process, because of course there are shareholder agreements, there's account receivables. Sometimes you may consider, and we had done this, is to look at bills of lading in order to anticipate where certain goods on behalf of the company will be delivered and see whether you can act there. So, but at the end of the day, we at this point will look at the financial flows in countries and in a shape or form that will help us all to formulate next steps and not miss out on any of the particular changes that may have happened since the beginning.
So looking at, moving on from investigation to claims, what claims can be formulated. as I think Colin mentioned earlier, there are a number of clawback claims this liquidator can pursue in order to unwind transactions or claw back value into the estate. In the example we've been discussing, the liquidator, the BVI liquidator, would have a choice of whether to do that in the BVI or seek to do that under the equivalent English law claims following recognition in the UK. These actions would include the types of actions, again, some of you will be extremely familiar with, so transaction undervalue, preference, transactions defrauding creditors, and misfeasance, so the typical English frame transactions. Also worth noting remedies such as the anti-deprivation rule, in which the English courts will not enforce an arrangement which would have the effect of removing assets from a company in liquidation. So that's another way that potentially in these circumstances you can use the insolvency toolkit. Again, under English insolvency law, any disposition of a company's property or any transfer of shares or alteration in the status of the company's members after the commencement of the winding up, being the date of the presentation of the petition, are void unless the court orders otherwise. Going back to our case study, if Mr. Vortex has received the money directly, which is unlikely, but assuming that, then these types of insolvency claims would be available to pursue directly against Mr. Vortex. Usually, and it's very likely that he would have used a range of intermediary entities and structures, and frequently family members, business associates, to create a number of transactions in which the monies are filtered out. It's going to be more difficult because of the way that those transactions are usually framed for the liquidator of Goldmine Limited to develop claims against the intermediary companies. And again, in this respect, this is something that the liquidator, our BVI liquidator here, Colin, would need to analyse in depth and analyse the transactions to see what claims could be brought directly against the intermediary companies. The liquidator would also want to examine what liability could be attributed to the intermediary companies. So this is essentially attribution of liability theories through their relationship with Mr. Vortex or any other of the bad actors, family members, business associates, etc. The types of attribution of liability theories that would be relevant here are the controlling mind principle, agency, vicarious liability, etc. The liquidator of Goldmine Limited will also want to consider what direct claims can be brought against the bad actors. And there are significant benefits of directly targeting the UBO, the ultimate beneficial owner here, Mr. Vortex. They could also attack other associated targets, such as family members or business associates, those persons that are involved in essentially extracting value and preventing the enforcement of the award. The types of claims that could be considered by the liquidator of Goldmine Limited in BVI would, in this case being BVI, would exist under both BVI and English law, certainly the first two. A key claim that we would consider in these circumstances, unlawful means conspiracy. It is, there is an evidential requirement, obviously, there, and that's why we would be working closely with the investigators, closely with the liquidators, and using the powers of investigation. But this is where two or more of the bad actors, so for here, for example, Mr. Vortex and his, and say a family member or family members, reached an understanding and intended to cause a financial loss and damage to Goldmine Limited, to Credit Limited, and or to Miss Wynne by the use of unlawful means. So it is quite a fitting cause of action to bring in these circumstances. It will often fit the facts, the challenges at the evidential stage. Tortious interference is another potential claim that one can bring in these circumstances. This is the wrongful interference or would relate to the wrongful interference with the payment of the award the payment of the award or judgment. This is a cause of action that is not particularly well developed in English law and certainly less so in BVI. We would also look at local BVI laws, such as fraudulent conveyance and anything like contempt of court in the BVI or in the UK as a result of breach of freezing orders. I mentioned one earlier, not appearing in the Section 236 hearing, etc. The purpose of the contempt of court process, for instance, would not to be to create a personal claim for money, but to actually add pressure and create pressure on the targets and create pressure across jurisdictions. We would need to consider very carefully, again, with the liquidator, which jurisdiction to proceed in terms of the direct claims. There would be, an analysis undertaken depending on the exact circumstances. The benefit of this approach is that it broadens the scope of recovery to include not just the judgment debtor, but also, usually, frequently, the person that sits behind the beneficial owner, but also those ancillary parties that assist the beneficial owner, the family members, the business associates. It will create immediate pressure on those persons, on those defendants to the proceedings. It will enable further discovery, disclosure, etc. And they will be engaged in legal proceedings from the start, and they will realise that this isn't just a case of creating a set of intermediary structures that distance themselves from the judgment or award, but it is something that is actually real and tangible in terms of their own position, their own assets. I guess at this stage, there's a very large super yacht sitting at the bottom of our case study in Cayman, and we would of course be looking at this to take control of. So I'll pass over to John.
Absolutely, thanks, Mark. So for the purposes of this element of the case study, we will assume that Sunseeker has security over the 30 million super yacht and that there has been a default in the underlying loan. If that is the case, the usual process that you would look to go through is to appoint a receiver. This can be done in very short order. You issue a demand. If there's a failure to pay, you can then immediately look to appoint a receiver. You then look to the security package itself to determine what the powers of the receiver are, what he can do, and how whatever notifications that he has to make. One of the key obligations of a receiver is to obtain the best price reasonably obtainable for the asset. And in this case, it's a 30 million super yacht. And this is obviously a movable asset. It's a very specialist area, the area of maritime law and seizure of assets like this. But I will highlight some of the key considerations that you need to keep in mind. So probably the first thing that you really need to establish is, where is the super yacht? Is it in a favourable port? Is it the case that you might want to move the super yacht to another port where you would have more favourable conditions to do a sale? There's a possibility there could be maritime liens over the yacht. You need to consider whether the crew and the master are cooperative or not. If you want to get them on side, usually you will pay whatever fees are outstanding to them, and in that case you might then be able to move the yacht to a more favourable jurisdiction port if you want to. You will need to establish if there are port fees that are payable. Again, these could become a lien on the yacht that you would need to deal with. So there's a whole number of elements that you need to consider when dealing with super yachts and various different jurisdictions that come into play. For instance, the super yacht might be subject to a lease, and that lease could be in another jurisdiction altogether. So again, more points to consider. There are also tax issues tend to arise when it comes to super yachts. We had a case not so long ago where we had a super yacht which was tied up in dry dock. So it wasn't on water where we could bring it into open sea and can do a sale there and not be subject to adverse tax. Unfortunately, it was in dry dock in Germany, which meant that there was a 20% tax VAT hit if we did the sale with the yacht in dry dock, and it was also subject to maritime liens. So there are a number of complex issues usually to consider when it comes to yachts and super yachts.
So just bringing some of these pieces together, we've looked at today or focused on offensive insolvency strategies and how we effectively prize open or mine into a corporate structure in the circumstances we've set out. As we mentioned, this uses a range of tools, provisional measures, provisional liquidation, freezing orders, receiverships, formal insolvency processes, and back-to-back appointment of joint liquidators, or appointment or controlling companies through appointment or control of the board of directors, the use of intercompany debts and cross defaults, recognition of insolvency proceedings in various jurisdictions, the investigation of bad actors and any misappropriations, and the use of insolvency-related claims or the use of direct claims against the targets. All of which, are the component parts are straightforward. It's the challenge is coordinating and combining all of the different aspects of this in order to achieve a successful outcome. It's worth bearing in mind at this stage that any judgment debtor, so on the other side, is going to be just as alive to the possibilities that insolvency tools and techniques create, but in a defensive way as opposed to an offensive way. Very frequently, the judgment debtor will be thinking of these much earlier than the judgment creditor. They'll be much more worried about their assets being taken than the judgment creditor's legal team, who are probably focused on the merits of the particular legal proceedings that they're in. Just to give a few examples, the judgment debtor may be looking, it's essentially a mirror image, but to create defensive layering of the relevant corporate structures, using an insolvency office holder's powers to resist enforcement efforts, to control any insolvency process, to control through that the entities, and to adjudicate creditors' claims, which could include the judgment creditors. So, there's a number of, and it's a whole topic in itself, but there's a number of different ways that the judgment debtor will be looking at, including, for instance, recognition and the impact of the automatic stay, which could obstruct enforcement efforts in a particular jurisdiction. So whilst we're not going to run through that in any detail, it is very, very worth bearing in mind that if you are on the offensive side, you need to think carefully about what the judgment debtor is doing on the defensive side and ensure that you put the right countermeasures in place. So just to add in a couple of points here, we're just going to move into funding considerations and just get a funding perspective in this area in enforcement. And I just have a couple of questions for Louise in this respect. The first is, do you think that the funding industry is sufficiently focused on enforcement as a part of the process and also as a commercial opportunity?
Thanks, Mark. So yes, this bit is the funding considerations. So the first thing I have to say is that it's quite difficult these days to refer to just a single funding industry. That industry has evolved and is evolving at a rapid pace now that there is some $15 billion at the last count, possibly more, thought to have been invested in this sector. There are special situation funds springing up to buy judgments with their sole mission being to enforce them. There are other funds emerging focused purely on funding the costs of enforcement. I was hearing at lunch just now that the private investigatory world is entering the market directly, Jules Kroll's firm K2 was chatting to me and told me that they've just, in the last few weeks, formed a new fund to pursue enforcements of judgments and form investigations. Mike over there can probably tell us a little bit more, but I understand that Grant Thornton recently announced the formation of a fund for similar purposes in the world of insolvency. But to get back to the question, the traditional funding industry, which, as I say, is rather losing its shape, has two very different answers to that question. Initially, part of the process, well, yes. If you've spoken to anyone in the funding industry for any amount of time, you'll gather they're pretty interested in enforcement. That is pretty much the main part of the process. And it's a good thing, because unlike lawyers, we're perhaps slightly less focused on winning the judgment or winning the award. We need to collect. Our success is completely measured in reward, not winning, so collection has to be front and center. And that you'll find common amongst all the funders. On the other hand, the other part of the question, I can say that until recently, traditional funders have not been so focused on enforcement as a commercial opportunity. Now, it's true that some players, Burford, made an early play in this regard. It purchased an enforcement investigatory arm. Might seem like a sensible move. And there are others following suit. But there are cultural forces at play here. I'm sure no one escaped the news about Burford earlier this summer. It came under fire for various issues, including the sex tape scandals, the commentary on whether enforcement should be caught at that kind of business or a discrete part of that business. The word sufficiently is particularly interesting, though. I think there's definitely scope and room for more specialised funders to become involved in funding. As the collection world becomes better capitalised and rationalised, so too the funding of particularly cross-border disputes are facilitated. I find it a shame that there are many, many, many good claims that go unfunded because of some kind of real or perceived collection risk. But if you have the right team who can adequately address those concerns, some specialists who are perhaps not involved at the initial assessment when you've got a prosecution team looking at the legal merits, but someone who can step in at the right moment and address that difficult collection risk, there's a whole world there for additional funding.
So the second question I had for you is how do you approach a funded matter where there is an asset recovery risk, specifically from a funder's perspective?
Well, again, any rational acting funder is going to look at recovery risk as a core rather than a secondary risk. Often it'll be the first thing that we look at. It's all very well spending your money, running up to court, going through trial, but essentially without collection, we can't pay our bills.
So do you think that funders are aware of the types of expertise, the types of tools and techniques available in enforcement to ensure their professionals are always adopting best practice, that they are always performing at the higher end of the spectrum rather than the lower?
Absolutely not. So traditionally, these two worlds have been completely separate, and that is now changing, in part for some of the reasons I discussed earlier, the new smart money entering the market, enforcement professionals creating their own bespoke funds, enforcement professionals working more directly with claim prosecution professionals. So the funding world is constantly evolving. But I like that you've mentioned best practice. That's something that we at Legis are obviously very keen to promote. But on a more serious point, it is time the industry adopted best practice, particularly in litigation funding. We believe that industry buy-in to best practices will help rationalise the funding industry, create more opportunities, and lead to a more sustainable evolution of how money comes into the legal process.
Thank you. So moving from funding finally to the investigators' perspective, do you have anything to add to the discussion today that we've
On Louise's point, actually, just now, what we're seeing is there is a movement towards working with litigation funders at the very early stages to help identify the amount of the award and actually just see whether it's at all worth it. So actually engaging investigators for that preliminary work can be incredibly beneficial for everyone, as we've been finding out. And I don't know whether you've been experiencing
Yeah,
that.
absolutely. I mean, it's, from a funder's perspective, you're going to come in at the beginning and you're going to try and assess where the assets are. If you've got no information, that's a very difficult investment decision to make. So having an investigator who's already done some of the work, or as we saw earlier, the collecting on a bank account, the working out the easiest assets, that will give a huge insight to the funder who's looking at this at the very beginning to try and work out how long and how much time it's going to take.
Absolutely. But also sort of similar to that point, at the end of the day, investigators are that channel between the world of information out there, which hopefully we're very good at finding, and people who design strategies to help their clients in the best possible way. So for us, I think it is quite critical to understand what is it that the team we're working with really wants and what is it that the ultimate client really wants. Do they want to launch a claim? Do they want to settle? Do they want to exert pressure? Do they want a claim as part of the bigger strategy? Because all of that will depend on how relevant and useful and, at the end of the day, financially efficient our work can be. And that can only really happen, again, if the whole team assembles together quite early on. We do often get situations where people have been working on a project for a very long time, and at the very last sort of 11th hour, they come and say, can you find the assets of these, I don't know, Russian oligarchs in the next 2 weeks? And the answer is, yeah, sure, but they probably won't be as good as the assets we would have found if we understood the wider, broader strategy and actually exchanged information. And, you know, it's providing leads to each other, and we've been finding that on the bigger, more ongoing cases, as we find more, the strategy changes, and actually ultimate goal may also shift. And it's sort of, so I'm a big advocate for working all together in a transparent fashion right from the word go. And I'll probably stop at that because I know we're running out of time.
Sure. Well, look, I will quickly wrap this up. I guess it's important to remember again that we've just been addressing one aspect of the enforcement toolkit. There are a range of measures that can include law enforcement initiatives. It can include using investigations offensively to understand areas of vulnerability and weakness. It can involve public relations to target a key primary concern of many of these types of individual, their reputation. All of this comes together, and it's really about the application of pressure to create a tipping point where it becomes more favourable for the judgment debtor to actually pay out than to keep on fighting. That involves a multi-layered, multi-jurisdictional strategy. It must be carefully controlled and carefully coordinated, as it usually involves a range of advisors across a range of jurisdictions. Any misstep by any one of those advisors can have a serious negative consequences for the enforcement. It involves a careful analysis of all the relationships involving the targets, financial, structural, corporate, personal, and it's really quite a cerebral and analytical process, as opposed to just following a set pattern of legal acts and steps. I guess it's worth bearing in mind as a final point that the economics are a key point to judgment enforcement. They're not on the side of the judgment creditor, they're actually on the side of the judgment debtor. The reason for that is the judgment debtor can spend a lot of money, in theory, up to the value of the judgment in defending the claim without losing anything, providing he is successful. The judgment creditor, on the other hand, particularly if a secondary financing entity such as a fund has come in, will, for every pound they spend, see a decreasing return on their money. And very quickly, if you have 100 million enforcement, and you've already spent, which we see very frequently, 15 million plus in fees, but the enforcement is still unsuccessful. If you're spending another 5, 10, 15 million, and the potential return is maybe 60, 70% through settlement or otherwise negotiation or the assets available, then very quickly the return on the investment on those monies is going to be unacceptable to both to either the creditor or the secondary financial entity. So this has to be a key part of the analysis, and that's something that is rarely done, but looking at the time frame over a period, the returns and the return on investment. With that, I think we're out of time, so probably no time for further comments or thoughts from the team, but otherwise we'll be very interested if anyone in the audience has any particular thoughts they would like to share with us in terms of what we discussed today.
What would you do if there was a discretionary trust?
Sorry, I didn't hear that.
What would you do if there was a discretionary? That's better. What would you do if there's a discretionary trust sat above mentioned Sunseeker and Resort?
We see trusts a lot in these types of situations, and they obviously present significant challenges. There's a number of ways that one can address those. So the answer to your question is, you would have to work your way through whether it's a corporate structure or a trust structure. It's the same thing, but obviously you're not necessarily going to be using insolvency tools and techniques for that. Anything further? Any other questions? No. Okay. Thank you very much.